everybody. Hope everyone is well. For those who don't know me, my name's Sam De Silva. I'm the chair of the BCS Law SG. So thank you for taking the time to attend this webinar. So we have got a couple of interesting speakers for you, speaking on quite an interesting topic. So we've got Kat Summer, who's the head of public affairs of NCC Group, and she heads their global cyber and software resilience, political engagement with government and other stakeholders. And then we've got Tom Darling, who's a senior account manager at Tendo Consulting, which is a political and communications consultancy. And they have done a lot of lobbying and sort of, I guess, engagement of various sort of policy things. So what are they sort of going to talk about is this thing called the CyberUp campaign. So it's their campaign to reform the UK's Computer Misuse Act, and they will sort of present a recent report they published that put forward a sort of a principles-based approach for the application of a statutory defence in legislation. As we all know, Computer Misuse Act has been around for a number of decades, and it's probably fair to say that it's probably not entirely fit for purpose with the sort of recent developments in technology and so forth. So it's probably time to revisit it. And I think Tom and Kat are sort of taking the lead on that. So I think we're all interested in hearing, about your campaign and, where it's going and next steps and so forth. So Tom, Kat, over to you.
Perfect. Tom, do you want to start sharing the screen with our presentation? Right, excellent. Perfect. I will do, there you go, wonderful. I was just about to say, I will do the Chris Whitty role of next slide, please, which we're all too used to. But what we thought we'd do is talk you through, in very brief terms, the industry case for reform. So present the arguments why the cybersecurity industry in the UK believes that the Computer Misuse Act does need reform. And we'll talk you through the main proposal that the CyberUp campaign has made. We'll then talk you through the defence framework that we have put forward in more detail. We then have the option of presenting you with a case study that would allow you to play through how that defence framework would actually be applied in practice to a real world example. But that is an option, and we can decide whether that is useful for you to do or whether you want to jump straight into the discussion and the Q&A. I should say before we jump in that neither Tom nor myself are lawyers or have any legal training beyond the sort of things you pick up when you try to dissect government legislation in the course of our day jobs. So what we have come up with in terms of the defence framework is what we believe is a constructive proposal that takes into account the political realities and the policy feedback we've had through our engagement with the relevant stakeholders in government. There will be things in there that if you are a lawyer by training, you will look at and go, not sure that would work. Very grateful for your feedback, but also while you review and think about that, bear in mind that it was devised by people without legal training. So be kind in your feedback, please. Next slide, please. So what we have found as an industry is that, well, it's basically rooted in the fact that the Computer Misuse Act was brought onto the statute book in 1990 when the cyber industry in the UK didn't really exist in its current form. So the basic premise of the Computer Misuse Act, which is to make the decision on whether something is legal or illegal on the basis of whether someone had authorization or written consent to undertake an activity, is a concept that is quite difficult to apply in modern cyber defense and modern cybersecurity practices. So we increasingly find that in the course of vulnerability research or threat intelligence research, there are instances where defensive work requires unauthorized access to computer systems that is de facto illegal under the Computer Misuse Act. While we've had some feedback that those instances of unauthorized access wouldn't necessarily be prosecuted, the fact remains that as a listed company for NCC or for other companies who have a duty of care towards their employees, they will not knowingly commit criminal offences under UK law, which means that a lot of the work that we would be technically able to do in the realm of vulnerability and threat intelligence research, we can't currently do because the Act is outdated and there is no legal basis to take into account an actor's motivations or to come up with a way in which certain acts of unauthorized access are defensible under the current law. Add to that the fact that there is a significant amount of ambiguity over what and what does not constitute breaches of the Computer Misuse Act, depending on which legal expert you speak to or what the interpretation of the law is at the moment. And you just have a legislative framework that is a bit of a nightmare for the cyber industry to operate, and that causes all sorts of issues in terms of international competitiveness, in terms of attractiveness of the industry for people to want to go into, and in terms of the contribution that we are able to make to defend the UK as a whole against cybercrime. We've all heard about the whole of society approach that the UK government is now taking to cyber and to cyber resilience and cyber security. That means that there is a clear recognition of the valuable role that the private sector has in sharing intelligence and information to support law enforcement and intelligence services operations against cyber criminals. However, what hasn't quite caught up with is that understanding that the right and the conducive legal framework is required for that whole of society approach to work well in practice. Very briefly, we have seen the consequences of that in that researchers who have disclosed vulnerabilities have faced legal threats and legal actions, even after the recipient of the vulnerability report initially acknowledged it in a grateful sort of way. So I think the legal uncertainty, the legal ambiguity, and therefore the threat and the personal risk that cybersecurity researchers take while they're trying to do the right thing is something that we think should be addressed quite urgently. Next slide, please. So just to reiterate, we do believe the Act is ambiguous, do believe it acts as a barrier. We do also believe that it doesn't at all protect legitimate cybersecurity activities as we would see them today, which is why the main proposal for reform that the CyberUp campaign has put forward is to amend the Act so that it introduces a statutory defence so that certain acts of unauthorised access can be defensible under certain conditions. Next slide, please. We've gone so far as to suggest proposed wording for an amendment for a new section to the Act to introduce that defence. What we have also found, however, next slide, please, is that whenever we raise the prospect of such a defence, of making certain acts of unauthorised access defensible, the pushback or the questions that we get is, doesn't this also create loopholes for the bad guys? So our argument is very clearly, we want greater leeway for the good guys to do their good job in helping catch the bad guys. The question is, well, once you introduce the defense, surely people will pop up left, right, and center and start to claim that the defense also applies to them. I should add, you know, in the interest of transparency and all that, Boris Johnson did not actually stand up at the dispatch box and ask that question, but it is a representation of the political feedback that we've had whenever we raise, or often when we raise, the concept of a statutory defence. So we went away, thought about that feedback, and in the spirit of, you know, wanting to propose constructive policy solutions rather than just raising concerns and challenges with the current act, try to come up with a way of answering that question, try to come up with a way of saying, we hear you, but we believe that we can devise a framework by which a statutory defence can be applied consistently and in such a way that still allows actual criminals to be prosecuted, while legitimate cyber professionals have greater legal clarity over their actions. Next slide, please. So that is what we set out to do. The purpose of this defence framework, in the context of a reformed Computer Misuse Act, would be to demonstrate that the defence can be applied successfully and consistently, and that it makes sense to everyone. We don't think that the defence framework as currently drafted would be part of the primary legislation that we think that will have to be brought forward. But in our minds, what the Reformed Act would say would introduce the defence, and it would then introduce a clause that would require the courts to have regard to this defence framework or a similar version thereof that could be more regularly updated, could keep pace with evolving industry practices and technology. So that we've got a primary legal mechanism to do this, while having a more flexible mechanism to go with the times, as it were. So we don't have to wait another 32 years or so until the Act can be reformed again, as it gets rapidly outdated. Next slide, please. And Tom will run through those. Just realised it's quite small. Tom will run through the details of our principles in the defence framework in more detail in a second, but I thought I'd just give the overview and also explain to you what we base this on, how we approach this. So what we did was come up with an initial view of, this is what we believe the principles are that someone should look at when they're judging whether a defence should apply, as in whether an act of unauthorised access should be defensible. We then went out to gather input from some legal experts and from industry to sense check our thinking, and as a result of that feedback, adjusted some of the principles, and explained where we kind of stuck to our guns in the final document. What we didn't want to do was to give an exhaustive list of examples that constitute defensible conduct or defensible unauthorized access, because it kind of limits the flexibility, which is why this idea of a principles-based defense, we believe, is the right way of doing it, because once the principles are agreed, their application to ever-changing perceptions of what is and or what should not be legitimate is more flexible. We are also basing this on the idea that a reverse legal burden would apply. So any defendant would have to prove and speak to those principles. And we think that while there is overlap across the 4 principles that we propose, we think that offers a safety net almost, in that all of those principles will have to be considered and will have to be found appropriate and applicable for the defence ultimately to be applied. So in very brief detail, the 4 principles that we look at is the harm benefit profile of an act. So what's the impact of harm versus the potential benefit derived from the act. We look at the proportionality of the act. So have reasonable steps been undertaken to minimize any risk associated with it. We'll look at the actor's intent. And when we speak about intent, we mean the good faith intention of the actor. So were they trying to do something in the public interest, in the interest of preventing crime or detecting crime, as opposed to nefarious motives such as a profit motive, financial gain, or other harms to be caused, other criminal intent. And we look at the actor's competence, which can be shown either through formal qualifications or a track record of previous good actions or behavior, or membership of a professional body, for example. And you'll be well aware that the government is currently consulting on professional standards for the cyber profession, and that the UK Cybersecurity Council will have quite a significant role to play in that. So those is at a top level, those are the principles that we're looking at. And I will shut up and let Tom take you through the detail of that. Before I do, I've seen that there are questions in the chat. If that is okay with everyone, we'll kind of come to them once we've gone through, because I'll be honest, my mental capacity to talk, present, while review and think of answers to the question is pretty limited at the moment. So if you're happy with that, we'll finish and then come back to questions and take it from there. Tom.
Thanks so much, Kat. Yes, sorry, wait, am I able to? I'm straight up there. Yeah, sorry. Yeah, so thank you very much, Kat. I just thought I'd say also that we put those proposals out to consultation with some of the legal academics and industry people we work with, but we're always looking to sort of review these proposals and keep the policy discussion moving forward and tinker with them. And while it was good for us to sort of set out our stall with this policy document, so we should also say, like, for background, the government reviewed the Computer Misuse Act in May 2021, so May of last year. It was obviously a big win for the campaign. It was the first time the government had taken any such step with regards to the legislation in its 30-year history, and it was something we were very much pushing towards. So we were really excited by that. We submitted to the consultation a long evidence review on why we thought it needed to be reformed. Unfortunately, as governments are wont to do from time to time, we haven't heard back much since then, and they have been saying, in response to parliamentary questions and media stories that we have been trying to place, that they will update Parliament on the outcome of the review shortly, and they've been doing that for 6 months. So I feel like potentially shortly will have arrived soon. So in terms of our political engagement, we're now focusing on trying to put a lot of political pressure on the Home Office to give their formal response to the consultation. And we can talk this. We should also say that this presentation that Kat and I are giving is fully focused on the policy proposals that we're putting forward, but we would be happy to discuss and take questions on all of our campaigning work and where we think things are in terms of the current situation with the reforms and what activity we've got planned in the future in terms of trying to get this over the line. Okay, so the principles, Kat ran through them there in brief, but I thought I would just go through them in a little bit more detail and explain why it is that we've included them, and then we can have some questions and a discussion. So principle 1, the prospective harm-benefit profile of the action. This would obviously, the inclusion of this principle obviously incentivizes behavior which minimizes risk and maximizes the benefits. The prospective comes out of the spectrum of, and I should say that the harms, and Kat mentioned this, the harms we're talking about here include damage to systems, sort of social or economic harms from a potential cyber attack or lost data, and then even at the most extreme end with some of the kinds of activity we're talking about, potential sort of geopolitical risks and harms. And then the benefits are fairly obvious, sort of reduced cybercrime, improved cyber resilience, and actionable intelligence that leads to either of those things, I guess. In terms of why we've said the prospective harms and benefits is because we can't, we're sort of focusing on what an action that an cybersecurity researcher might take, the typical sort of results of that action when used, and that's a sort of recognition that cyberspace is very sort of dynamic environment, and that things don't always go according to plan. So that is the reason for the inclusion of that. As Kat mentioned, right, I think, oh sorry, that was these are the harms and benefits that I just mentioned. But we've also put together this sort of quadrant, and I mentioned the prospective harm benefit, this sort of matrix of where you could place different actions where they would typically lie, so different cybersecurity activities that cybersecurity professionals can carry out in order to achieve what they're trying to achieve. And then you can see the four sort of quadrants of the diagram, and where an act causes harm and delivers benefit, so it's possibly defensible, and where an act causes no or limited harm and delivers no benefit, it's possibly defensible, and an act that causes no or limited harm and delivers benefit is defensible, and then at the other end, an act that causes harm and delivers no limited benefit is indefensible. So, and Kat mentioned us, we're very explicit when we started this activity of not wanting to place specific activities on this quadrant at this point, because of the fact that there is some temptation, I think, within our discussions with the government, that they would like to see something, they would like to be able to say, well, doing this is illegal and doing this is legal. But I think, as Kat made really clear, that potentially limits you in terms of the future proofing of the legislation, because the activities and the techniques that are used changes so rapidly. You would potentially be sort of anchoring the legislation in that sort of the accepted consensus at that time, whereas we want something that's future-proofed. That said, we are currently thinking about doing a piece of work where we survey cybersecurity professionals on their views as to what things they think ought to be illegal and legal, and why, or defensible and indefensible, and why, because we think it would be useful, and we get, as I said, get feedback from Home Office officials that it would be useful to them to have a bit of an understanding of what we're talking about here, even if that wasn't something that was going into, definitely not legislation, but nor Home Office guidance either. Principle 2, the proportionality of the Act. So could the same outcome have been achieved by less intrusive means? And did the researcher take all reasonable steps to minimize potential harms? Again, this disincentivizes risky behavior, but it's also something that is quite a common legal principle, I think, and it comes out of the Dutch prosecutorial test. So we've done some work with the Criminal Law Reform Now network, which Kat may have mentioned earlier, and some of you may be aware of, looking at the different legal frameworks in other countries. And in the Netherlands, they have clear prosecutorial tests for whether or not a prosecutor will take a case and will pursue a case. And one of them is very similar to this in terms of did they act proportionally? And I think I'm right in saying it's common across sort of other legal areas. So that is the proportionality of the Act. The Act's intent. So I think, as Kat was sort of laying out at the start there, our key contention is that the CMA, as it's currently written, does not take account of an actor's motivation at all. So it's no surprise then that this should be included in the, we think that this should be included as one of the principles that is applied. And there's a lot, I think you can quite quickly get into debates of, well, how do you prove intent? And it's very difficult to prove intent. The sort of criminal lawyers that we work with actually think that, you can get quite bogged down in those sorts of debates, but there are things that you can look at to determine what someone's intent was, including subsequent conduct, which we actually originally had as a fifth principle, but we were advised that it's more appropriate to be as indicative of intent. So did they disclose a vulnerability in a timely manner? Did they share information with law enforcement in a timely manner? Did they have full and swift cooperation with the relevant accreditation bodies or authorities, etc.? So that's intent, and I guess that's a sort of key dividing line in a lot of the criminal law between good and bad conduct, good and bad actors, I should say. And then principle 4, as Kat mentioned, an actor has shown competence, which is a combination of authority and expertise. So it has the actor shown those attributes. It falls out of some of the discussions that we had about limiting the list to a certain register. So that's an idea that's been knocking around for a while since we started this campaign. Is the idea of having an sort of an a priori defense or a list-based defense, where you have certain actors who are able to, who apply for a defense or are able to do these things, and there's a list kept of who that is, and they have to publish logs and stuff, in the same way that, I don't know, you might have like defense contractors or given certain levels of security clearance. Would you be able to operate a similar kind of system where statutory defense operates in terms of a list? I think there's a lot of, certainly in the academic community, there's a lot of pushback to that, and there's a lot people favour a sort of broader defence that is follows certain principles. And I think that's where we've ultimately landed, is to say that that is probably too limited, and that actually you want a system that can take account of an actor's qualification, so that is not neither necessary nor sufficient, but it does count towards whether or not you're going to be eligible for a defence. Their membership of a professional org, compliance with a code of ethics, so signed up to a code of ethics, capacity at the time of a work in question. So like a lot of cybersecurity researchers are members of bug bounty programs with like reputable organizations, and as part of that, they sign, they'll be signing contracts of employment and meeting certain standards in terms of their work. That will count towards their eligibility for a defence, their prior track record, have they done in the past been part of successful, good faith cybersecurity work, and act as previous associations as well. We should say that we've included sort of prior track record because, you know, a lot of cybersecurity researchers are kind of self-taught and don't necessarily have sort of typical academic backgrounds, and we felt it would be wrong to exclude someone and say, well, you need to. And then the other thing to say is also accreditation bodies as they are now can be they can involve some difficult hoops to jump through, and not everyone is able to jump through those hoops, and that shouldn't preclude them from having access, from being able to access a statutory defence. So I think that's kind of it, actually, in terms of the principles. We do have a case study, but I think it might be actually probably a better idea. I just think our case study, when we've given this presentation before, we've given people hard copies of it. And we might, if people wanted to, we could read through that case study, or we could open up for discussion now. What does the chair think? We will leave it to you.
How long will the case studies take, Tom?
What do you reckon, Kat? 10 minutes?
Yeah,
that's fine. I mean, you've got till sort of 7:30 really sort of penciled in. So yeah, very happy for you to continue. Okay,
Kat, do you want? It's not so. Do you want to maybe read out the case study, or is it?
Yeah, I was thinking whether I'd share it on the screen and allow people to, and just leave it up and share it there. What do you reckon?
Yeah, that's fine, Kat. Yeah.
Or maybe, yeah, put it in the chat. The document.
Yeah. It's probably. Yeah, I guess so. Or you could share it on the screen. Yeah.
I will try and share it in the chat. See if technology allows it. This is when we find out. Oh, fair enough. Let's see. It should be, no, I've sent it to the wrong person. Let me try again. It's only a matter of time until I get it correct. There you go. That should be in the chat now.
Be careful of the malware.
Quite. Yeah. You jest. I will just see if I can, while people open it on their own computers, I'll just see if I can bring it up on the screen as well, so we're all looking at the same thing.
Do you have to save it first, Kat? When I click it, it asks me to save it.
Oh, potentially.
Okay.
I've not actually, I have to admit, I've not actually
okay.
tried that mechanism before.
Sure. Nice.
Has it come up?
Yeah.
Yeah.
Cool. So effectively, this is a real world example. Because as we are continuing to kind of make the case for reform, we are keeping a track of what people in other jurisdictions are doing in terms of the threat intelligence work and the investigations they are undertaking. And our main lens through which we view that is normally, I wonder if we'd been able to do this in the UK under the Computer Misuse Act. So this example is one of a Dutch-based threat researcher working for Trend Micro. They could be working for anyone, they just happen to work for Trend Micro. And they presented to Black Hat in November last year and showed the findings of an investigation, a threat research they'd been undertaken. It was given to Forbes as an exclusive, as you tend to do when you're a commercial or work for a commercial firm. You kind of try to get as much exposure for your findings as you possibly can, so that in itself isn't necessarily something questionable. What we saw from the research report that was published in the Forbes article is that the researcher, FICA Hackerboard, identified a previously unknown threat actor and gained insight into their operations. Again, that is, the normal course of threat intelligence research. That's what threat intelligence research is. Therefore, you try to understand who the adversary is and what they're doing, so you can devise the defenses to defend against them and protect your systems and operations against their attacks. What Hackerboard did was identify the actor's domain and the actor's command and control cell, so the control panel, which that group used to monitor their victims. The Forbes article says that no password was required to gain access. What we don't know, and unless we ask the question of Hackerboard himself, is whether that IP address was actually available on the open internet or not. What we know is that as a result of the access that Hackerboard gained to the domain of the control panel, he was able to collect email addresses of those individuals and companies who were targeted by that group for malware deployment, and he had a pretty good idea of who they were, and therefore was able to say, that criminal group went after telecoms, after ATM machine vendors, fintech companies, and others. What the research report that he published and upon which the Black Hat presentation was based also showed that Hackerboard observed the group for 1 year after initially gaining access to collect the information. And from what we gather from what is publicly available information is that he'd informed a handful of the group's victims and planned to share information with law enforcement. Trend Micro has made available the indicators of compromise, again, part of the rationale for threat intelligence research in the first place, to allow other organizations to see if they've been targeted by that threat actor. Hackerboard himself has 15 years experience in threat research, and he's regularly advised international law enforcement agencies on investigations. So we've sort of tried to pull together the information that is relevant to that specific case to then allow us to apply the defense framework and go through the different principles. Now, I don't know whether people are happy to kind of be called upon or raise their hands and kind of share their observations up for each principle, looking at that particular case study, or whether you just want us to run through kind of our assessment and our understanding of how we would judge that specific case against the defense framework. I'm very happy to do either. Sam, what do you think?
Yeah, I guess we could get people to raise, I guess they could raise their hands electronically. Would that work?
I would
yes,
think
they
so.
can raise their hands.
Well, let's see if that works in that case. So if we look at principle 1, as Tom sort of explained in detail, that is the prospective harm benefit profile of the Act. What we're looking at is whether the benefits of what Hackerboard in that case did outweigh the harms, including whether his action was necessary to prevent a greater harm. So looking at that principle and looking at what we know of how Hackerboard conducted his threat research, what do people think, or how do people feel about the applicability of Principle 1? I'm just gonna
Kat,
say,
sorry, Kat, could you, just got a comment, could you increase the size of the document?
There was a hand raised from Graham.
I can. Does that help? Is that getting a bit bigger?
Yeah, I think that's better. Thank you.
There you go. Graham, I think, raised his hand. Do you want to just come off mute and speak?
Well, I was just actually raising my hand to say that, in my opinion, it satisfied Principle 1.
Very good.
I think we agree with that.
Yeah, I think that's the conclusion we came to when we did the same thing. Cool. Let's go through them. Principle 2. Any views? Graham, Trooper, keep going. Oops, sorry, I keep scrolling. I'll just, so I think, you know, we took the view that Principle 2 was met as well. I might speed this up a little bit and then we can maybe debate about our on our interpretation as well. We also took the view that on Principle 4, the actor's competence, from what we know and are able to ascertain, that principle would be applicable, would be proven as well, based on his experience, based on his education, based on his previous track record and previous activities. He, you know, seems to have been a good guy in the past and has got the track record under his belt to meet the competence principle. The principle that we raised questions on was Principle 3. Was the actor's intent, again on the basis of the available information, which, you know, let's be clear, if this was an actual case in an actual court, obviously the court would have a lot more detailed information available to make their judgment and their assessment. But what really struck us as questionable, actually based on proportionality and intent, is the fact that he observed the group for a year. So after the initial access, he just kind of stayed in their systems for a year on his own account, from what we can gather, to see what they were up to, which does raise some questions of proportionality, because in order to understand that they were a criminal group doing shady things, it's questionable whether 12 months of potentially unauthorized access to their control panel was needed. And on Principle 3, the actors intend the fact that the Forbes article, which is a media article, press article, stated that only a handful of victims had been informed and that he had plans to go to law enforcement to share his findings, just raised questions for us. And as Tom said, if we're looking at subsequent conduct and timeliness of disclosure of information as one of the factors to consider when looking at the actor's intent, part of the question to be raised in this particular example was whether he was after the publicity first and foremost, or whether his intention really was to identify a threat actor and warn potential victims so they could avoid falling victim to that threat actor. So I think in our assessment, we sort of show that the application of the defence framework is doable even on relatively limited information. It's sensible. It does lead us to ask the right questions when judging the threat researchers' activities and conduct, and it kind of on balance leads to what instinctively was the right conclusion when we reviewed that example. I'm just going to leave that stand there. And very, very happy.
If I could make a couple
of
points, if that's all right. I think I would just say that, this, I think one point to make is that this is all done on the basis of publicly available information, and that a jury might come to a different conclusion, and a jury, of course, has more access to more information and is able to compel testimony and retrieve documents, etc., etc. So there might turn out that there's a good reason for this that comes out in the court proceedings that isn't available to us from the publicly available information. So that's just one thing to bear in mind. And I think Kat really hit on the issue, which is that we feel like this is at least asking you to ask the right questions with regards to whether or not this should be a criminal act. These kinds of issues of proportionality, intent, harm, benefit profile, competence, you feel like you're getting at the nub of whether or not this is something that ought to be criminal. Whereas with the current law, that's really not what you're thinking about at all with the CMA as it's written. And we've spoken to a guy called Daniel Cuthbert, who some of you might have heard about, Daniel Cuthbert, who was convicted under the CMA in 2005, I think. I think the judge, in convicting him, sort of said, well, I don't think this should be illegal, but I have no choice because this is the way the law is. So actually, with the law as it is, you end up discussing this principle of authorization, which I think someone has highlighted too, is incredibly vague, and you don't actually discuss whether or not it's a criminal act, so that would be the additional points that I would make.
Cool. I will.
There are a number of questions in the chat. Ian Henderson asked that surely this also violates Principle 2. And then there was another question from Leroy. Can the panel say the relation with NCSC? So I don't know if you wish to take this at a later stage, or if you would like to answer to some of these questions now. Tom and Kat.
Yes. Yeah. Shall we go through them?
Mm-hmm.
Cool. Yeah. So Ian, yes, absolutely. Question Principle 2 as well. Yes, you are absolutely right. Just to clarify, that is the fact of a year's access does question the proportionality principle. Yeah, Rob makes a very good point. I mean, I think it's visible for everyone, but the question to ask is, at what point in this year did Hackabot obtain the data for the 3,500 users? If it was right at the beginning, yes, you should have acted sooner. If that data gathering process took longer, a delay is more defensible. And again, you're right. And again, to Tom's point, we're judging this on the basis of publicly available information, which, by its very nature is limited. But I think what it does show is, to just reinforce what Tom said, that you start to ask appropriate questions looking at acts of unauthorized access in detail, judging them on the merit of the action, as it were, as opposed to whether they hit the very binary definition of authorized or unauthorized access. And I think but the the argument that we're making for reform of the Computer Misuse Act, that in today's digitalized world and the modern cyber defense practices that we're operating within, those are the questions that should be asked, rather than relying on a concept that was appropriate, excuse me, more than 30 years ago.
And Kat, there was another question from Rob Thomas, who also raised his hand earlier. The question I would like to ask is at what point in this year he obtained the data for the 3,500 users. If it was right at the beginning of the year, he should have acted sooner. If the data gathering process took longer. I don't know if Rob, you want to take the floor, raise your question.
Well, I think they addressed that just now.
Okay.
It's we have to base it on what we know publicly, and we don't know this information. But it's an interesting point. I mean, if he was able to get this data right at the beginning, and he knew these people were compromised, then yeah, in my opinion, he shouldn't have sat there observing for a year. If he got that data right at the end of that year, and all of a sudden he's got this data on 3,500 users, and he went public at that point, then, you know, fair play to him. He's done a good job. We just don't know. We just don't know in the absence of information.
Yeah. And I think Sam's question around the system was unprotected, publicly available to everyone, so they say. So again, yeah, you could even argue that it wasn't unauthorized access in the first place. There is, you know, Sheila raises really interesting questions. What reason did the company give for starting the investigation? You know, was it curiosity? Was it to improve their knowledge? Was it to make money?
Yeah.
You know, arguably, Trend Micro is a cybersecurity firm. They benefit from the publicity they gain of the back of the research that they undertake and publish. That's not to be held against them. And in the course of that research, yeah, they do uncover, you know, really relevant, really insightful information and intelligence that they will share with law enforcement. I think the point for us there was, and that, again, that might just be the way in which the Forbes article formulated what had happened, but that he went to the press and the press reported that he planned to share his findings with law enforcement. You sort of go, okay, so that leads us to question the motive or the intent, really.
Yeah, and it's worth also saying that in the sort of InfoSec community, I think there's definitely a sort of online culture of self-promotion of the work that you do a little bit, and also one-upmanship, and it gets quite competitive. So I think that can, maybe that's, you know, for a jury to disentangle where the line should be drawn in terms of how much was this. How much did they want to get ahead and further their career and be someone who's done these really cool investigations? Cloud, actually, did they take the right steps here in order to make sure that harm was minimized, etc., etc.?
Yeah.
There was also an earlier question from Stephen Castelli on the unauthorized access example. I don't know if Stephen would also like to take the floor.
Can the speakers give an example of legitimate unauthorized access? Can you?
I mean, hopefully some of the example has gone some way to answer that. In addition, things like vulnerability research, where a researcher, without gaining prior consent of the manufacturer of say a smart speaker, conducts research on a smart speaker they've purchased or the associated software, finds a vulnerability, finds a critical flaw that would expose, say, the personal information of 10,000 individuals, and reports that to the manufacturer. The manufacturer could turn around and say, well, thank you very much, but also in giving me this information, you have provided evidence that you have broken the Computer Misuse Act. That should be defensible unauthorized access, because the interest in identifying vulnerabilities, disclosing them so they can be remedied, is, you know, an act of public interest, an act of clear intent to improve cyber resilience, improve cyber security, that should be defensible. Likewise, acts of unauthorized access that would gain access to criminal service or criminal infrastructure to ultimately undertake what Hackabot did, to identify who these people are, who they are after, and what methods they are using, so the right people can be warned in collaboration with law enforcement and right authorities, of course, can be warned to take protective and preventive measures so they avoid falling victim to that, are the sort of things that we have in mind. The challenge, to Tom's point earlier, the challenge is that you could take the approach of, we'll just write a long list of legitimate acts of unauthorized access, and that's the exclusive list of what is permissible under the Act, undertaken by the right people. But as Tom's also outlined, there are clear limitations to that approach. Stephen, you have a very long comment unpicking the concept of unauthorized access. Is it worth you talking us through that?
This is Stephen. This is he. Hi.
Hi, Stephen.
I'll just let that lie. You can read papers I've written over the last 35 years. As somebody that was involved, as many others were, in advising and submitting to the Lindop Committee, and the Law Commission at the time, and indeed the draftsman assisting in the drafting of the original Computer Misuse Act, many of us were disappointed with the way it came out, with even defining a concept as a cornerstone of it, of authorized access, which is actually a nonsense concept in systems engineering terms. But let's not discuss that, because we obviously have the Act as it is, and now you're trying to add something to it that one can only applaud. I didn't put it on the chat, but if I may, I find the difficulty with your idea of benefits and harms, because again, these are highly subjective human judgments, and also the populations who might benefit as opposed to the populations who might be harmed could be quite different and quite orthogonal to each other. You keep talking about a public interest or a public benefit, which is very nebulous and very undefined. And who is the public, and which public are you talking about, and whose view of the public interest do we take as being the public interest, as against to, so that's a benefit if something is done, if an access is done that's in the public interest, let us say, or a benefit to the public at large. Very nebulous concept, very subjective. On the other hand, that access, that illegal act, or that act, let's not call it illegal, may be of severe harm to a quite different population of people. If somebody hacks into a company's database, steals all public data, and then writes a paper saying they did it to show the vulnerability, it may have severely damaged that company's business, reputation, ability to go on trading, particularly if it's one that is dependent, as most companies now are, on showing that it has reasonable cybersecurity and reasonably secure and safe data privacy and functioning systems. So the people who are going to benefit against the people who are going to be hard are completely different populations and communities. So I think trying to gauge the benefits to one set of communities, which is a subjective thing, versus the harm to other as a means of discriminating whether somebody can carry out a supposedly illegal act is riven with problems from the start. And I'm wondering whether that was even the right place to start. That's all. I'm not trying to criticize you. I'm just I'm just registering that I see that as a fundamental problem with this whole model that you're trying to graft onto or advise people to try and amend the Computer Misuse Act. That's it, really.
That is very, very useful. I think we'll just let that that comment rest, because I think part of why we're doing these sort of events and sharing ideas is to get exactly that sort of feedback. Because while we're very clever, obviously, we don't know it all, and we obviously don't have all the answers, and we can't think of all the things. So that kind of feedback is very valuable and will inform the kind of further thinking and next iteration of how we take this forward and what other things we might want to suggest and propose.
I just see one last question from Graham Kitterington. The question of how long law enforcement should observe criminal behavior to gain more intelligence before acting to close down the criminal behavior arises in all branches of investigation. So the how long is what Graham puts in question. I don't know if Graham, you want to take the floor. Otherwise, feel free, cut and talk.
Again, I was making more of an observation and a comment rather than a question here, because I just say this is a sort of an issue that law enforcement people are going to be wrestling with all the time, really. Well, whenever they're in an intelligence gathering sort of role, you know, at what stage do you actually act, or to what stage do you hope that perhaps, for example, if you observe the criminal behavior for a bit, you might get an insight deeper into the criminal operation, and therefore you might be able to take out a whole operation rather than cutting off one or two of the tentacles of that operation. So I was just really commenting that, you know, I think you're actually touching on issues here that are common across quite a broad perspective, a broad spectrum of law enforcement.
Yeah.
Yeah, completely agree. That's a great point.
Yeah. And I think Leroy asked about collaboration or work with NCSC. NCSC are aware of the CyberUp campaign. As far as I understand, they are broadly supportive of the thinking and the principles behind it, not least because they obviously work very closely with industry and benefit from industry insight and intelligence in their own threat operations. As NCC Group, we support the NCSC I100 Industry 100 scheme, and are, you know, proud to be a partner of NCSC in the shared pursuit of the mission to keep the UK safe and secure online.
I think that might be us having addressed all of the questions that are in the, oh, here's a question.
So there is an additional question from Sila about.
I don't think that is a question.
Yeah, but it's a statement of what unauthorized is. So
it's just a statement.
Sila, you took the floor.
No, it's just a statement. I actually disagree with Stephen about what makes authorized and not authorized. So I wanted to give you that view to consider.
That's great. Thank you very much. Just to spell it out, I guess, or people can read the chat. I wonder if there are any other questions that people have.
I don't see any other questions in the chat. I don't know if any of the speakers wishes to take the floor. Raise his hand now. Otherwise, I don't see any further questions. And I would suggest the floor to Sam and then the speakers. Thank you from my side.
Yeah, Tom, Kat, do you have anything you want to wrap up?
Yeah, that's okay. I might just
sure.
Might just say thank you very much for having us, first of all, and second of all, if anyone wants to get in touch with us or feels like that this is something that you'd be broadly supportive of and want to hear about updates as the campaign sort of moves along, our website is cyberupcampaign.co.uk, I think, maybe .org.com. So Kat has put it in the chat. So you can go in there and sort of put your email address in, and we'll send you updates. Maybe we probably only send them every 2 or 3 months, so you're not going to be bombarded with emails. But if you want to hear from us as we keep going along this journey, feel free to do that.
Yeah, and all the reports and the research that we've published is on there as well. So if you feel inspired to delve deeper into the world of CyberUp, please do. If you want to, offer further perspectives, experience of, I don't know, potentially having defended security researchers in courts, or having advised other bodies on how to draft appropriate cybercrime legislation, we'd love to hear from you as well. As far as we're concerned, this is going to take some time yet before government action happens. We are trying our utmost to speed the process along, not least by presenting workable solutions, hopefully. If you want to help us do that, we would love to take you up on that offer of help. I think it's fair to say. But yeah, I think the more people get involved, the more people spread the word, the more people feel inspired to write to their local MP, ask why reform of the Computer Misuse Act has not yet been forthcoming, the better, and the more difficult it'll become to ignore calls for reform by the political powers that be, would be my closing remark. Likewise, if you think we're barking up the completely wrong tree and you think the Computer Misuse Act is absolutely fit for purpose and should remain as is, also, please let us know why you think that.
We have a special folder for those.
Tom.
Is that called spam, Tom? Okay, great. Well, thanks very much, Tom and Ken. I think that was really useful to know what was going on and your sort of, I guess, plans and thoughts. And yeah, thank you, I guess, for, leading the charge on that. I think it's not an easy task, as you probably know. So yeah, I hope you get the support you need. And as Kat and Tom said, if any of you want to reach out to Kat and Tom, feel free to. So, and one thing Kat didn't mention is she wasn't feeling very well, so she soldiered on and gave the presentation. So really appreciate that, Kat, instead of cancelling at the last minute. So thank you for that and leaving Tom in the lurch. So I think you made a good double act. So thank you all for attending. So stay tuned for our next event. And we're doing this for the benefit of the community. So if you've got any ideas, events, or that you want us covered, or if you want to be a speaker and you think you can add value, feel free to email me or Panajata, and we can discuss that further. So thank you very much. Have a good evening and keep safe. Thank you.